defendant's refusal to issue NOC to the complainant. 2, an order of perpetual injunction restraining the defendant from forcefully ejecting the complainant from his official quarters at number 6 Oladende Street, Anthony Village, Lagos, until all his benefits have been paid. 3, a declaration that the defendant's refusal to issue no objection, clearance, NOC to the complainant after terminating his employment and failure to pay his dues are illegal and inhuman. 4, an order of injunction compelling the defendant to issue no objection, clearance to NOC to the complainant to enable him to secure alternative employment. 5, general damages. The defendant filed its statement of defense together with the accompanying processes and the counterclaim on 26th of March 2018. The defendant counterclaimed as follows. A, the declaration that the continued occupation and or possession of the defendant's counterclaimant's company's accommodation given to the claimant to counterclaim in the course of his employment with the defendant to counterclaimant after the claimant's defendant to counterclaim had voluntarily resigned his employment with the defendant's counterclaimant company was unlawful and unjustified. B, damages in the form of naira for the unlawful continued occupation and or possession of the defendant's counterclaimant company's accommodation after the claimant's defendant to counterclaim had voluntarily resigned his employment with the claimant's defendant to counterclaim company. C, award of the sum of 1,039,090 naira being refund of the overpayment stroke excess of settlement of the claimant's defendant to counterclaim final entitlement, as shown in the table in paragraph 9 above. D, 500,000 naira costs of the suit. The claimant filed a reply and a defense to the counterclaim on 7th of May 2018. I will go straight to the decision portion. All the submissions are included in the judgment. I have carefully considered the processes, the evidence, submissions of counsel, and authorities relied on in the final address. Learned counsel to the claimants in paragraph 5.1 of the final address has stated that the claimant's claim number 2, seeking an injunctive relief, is now academic as a result of the defendant's forceful ejection of the claimant from the premises. Consequently, this head of claim is hereby struck out. The law is that in the determination of employment rights, it is the employee who complains that his employment contract has been breached that has the burden to place before the courts the terms and conditions of his employment that provides for his rights and obligations. Okoibo versus Council, Okomo Oil Palm is Serere, C. Idoniboye Obu versus NNPC. It is also the law that whosoever desires the court to give judgment as to any legal rights, liability, dependent on the evidence of facts he asserts, must prove those facts exist. Section 1 and 2 of the Evidence Act. Also see Calabar Cooperative Limited versus ECBO. The issues that arise for determination are as follows. 1. Whether on the pleadings and evidence the claimant to the reliefs he is seeking. 2. Whether the defendant counterclaim has proved the counterclaim. The claimant is contract of employment, Exhibit C1, which both contain the terms and conditions of his employment. The law is set the conditions of service, rules, and regulations in a contract of employment bind both the employer and the employee equally. See the case of DA Alep, Nigeria Limited versus Oluwadari. The claimant has that he resigned on 30th of June 2015 and completed his handover on 30th July 2015 in compliance with the service agreement Exhibit 2. He did not hand over. I believe the evidence on this. The defendant pleadings admit the claimant's resignation, and DW on the position has admitted that the claimant resigned on 30th 2015 and his resignation was accepted. Now, clause 14.1 in the service agreement provides, and I quote, each party has the right to terminate the agreement by giving each other a month's notice in advance. The company may, at discretion, pay 1 month to that effect. However, the expatriate cannot to have left the company's employment without having an account within the period stipulated according to the formalities in practice. I find from the evidence that the claimant gave resignation on 30th June 2015. By the above 3.1 in the contract of employment, the claimant cannot be to have left the claimant's employment without rendering his accounts and handing over same within the period of 1 month. I also found within the notice period of 1 month rendered and handed to the defendant's managing director. I hold claimant an employee of the defendant until 30th July 2015. He is therefore entitled to his salary allowances for the month of July 2015 in the sum of 6,000 United States dollars at the exchange rate of 245 naira. The claimant has made a claim of the sum of 5,012,772 naira as unpaid salary, leave allowance, economy travel tickets, amounts lost due to the refusal to pay increment, and amount lost due to the defendant's refusal to issue him a no objection clearance. The claimant's employment that he shall receive on a monthly basis the naira equivalent of 5,500 US dollars in salaries and various accounts for the first 12 months of employment, and 6,000 United States dollars thereafter, 30 days annual leave plus economy tickets for the claimant and spouse, economy air tickets to return to India at the end of the employment, From the totality of accused, I find that the following payments are not in dispute by the parties. And these payments are computed as follows. Excess excuse me, please. Excess 504,125 naira 81 kobo. Excess medical 91,800 naira. Payments received April 2015 48940. May 2015 7,500. June 2015 781,650, making a total of 1,090. Additional payments received 1.5 million and 500,000, making a total sum of 4,662,000. The claimant is also entitled to receive an incremental pay of $500 after 2 months by the contract of employment. The claimant ought to have begun the incremental pay on 1st December 2014, but he did not. He has made to the court. The defendant in its computation indicated this incremental pay for the months of April, May, and June only. The claimant and the defendant are equally in agreement about the excess time spent when the claimant went on leave. This has been reflected in the computation above. The claimant has equally claimed for leave salary. The claimant is entitled to 30 calendar days per annum. The claimant has from December 1, 2013 to July 30, 2015. That is a period of 20 months. Claimant is therefore entitled to an additional prorated period of 8 months, which he has indicated in Exhibit C3 as leave salary. From the totality of evidence placed before the court by both parties, I find that the actual sum due to the claimant, as computed below, is 2,339,034 naira 19 kobo. The computation is as follows. April 2015 salary, 1,240,050 naira. May 2015 salary, 1,240,050 naira. June 2015 salary, 1,250,850, making a total of 3,663,500 naira. Prorated leave entitlement $6,000 of 455 naira, 8/12, comes to 980,000. 500 at the exchange rate of 200 comes to 807,000. July salary, $6,000 at the exchange rate of 245 comes to 1,470,000, making a total of 6,950 naira, less payment received by the claimant, 4,632,015 naira 81 kobo, leaving a balance, credit balance of 2,334 naira 19 kobo as due to the claimant. The claimant a declaratory on the grounds of the claimant's refusal to issue him a no objection clearance after his employment and failing to pay his outstanding salaries and allowances is illegal and inhuman. From the evidence, the defendant did not terminate the claimant's employment. Rather, the claimant voluntarily resigned his employment. The service agreement in clause 5.1.15 that the claimant not to use the immigration facilities of the defendant to seek another employment in Nigeria without the written consent of the defendant. A written consent or NOC from the defendant is not a right that inures to the claimant in the employment contract. Rather, a written consent or NOC is entirely at the discretion of the defendant. The defendant refused to exercise this discretion in favor of the claimant and has given the reason as the failure to give up possession of its premises after the claimant's voluntary resignation. Consequently, claims 3 and 4 must fail. They are hereby refused. The claimant has a claim for general damages. The claimant is an expatriate Indian recruited to work for the defendant's company. The defendant failed to pay US dollars salary allowances that ought to have been paid to him from December 1, 2014 to July 3, 2015. Furthermore, his salary and allowances for the period April, May, June, July 2015 were not paid to him as the incremental salary of 500 US dollars is expressly related in the employment contract. The law is set that parties are barred by the employment contract. Where a party fails to comply with the terms, it amounts to a breach of contract. I find that the defendant breached this term of the contract. I must make the point that every worker stroke employee is entitled to pay his or her salary and wages as at when due. Where this is not done, it works extreme hardship on the employee or the worker. The claimant has given evidence of how the defendant made his life difficult by its failure to pay him his agreed salaries at the due date and time. The claimant's unchallenged evidence is that he could not leave Nigeria without collecting his outstanding salaries and allowances. He could not secure another result of immigration laws. The defendant forcefully evicted him from its premises. I am satisfied that the claimant, from all of this, is entitled to an award of general damages pursuant to the provisions of Section 19D of the National Industrial Court Act 2006. I therefore award the sum of 6,000 United States dollars, being the equivalent of 1 month salary as general damages to the claimant. This sum is paid by the defendant in the Naira equivalent using the official rate ruling on the date of payment. On the whole, the claimant's claim on paid salaries and allowances succeeds. The defendant is ordered to pay the claimant the sum of 2,339,034 naira and 19 kobo being unpaid salaries and allowances, the sum of $6,000 being the equivalent of salary and general damages within 14 days. Thereafter, 10% interest per annum, compounded every month, will be paid on the sum or any part outstanding until final liquidation. Cost of 250,000 naira awarded the claimant on the main. On the counterclaim, the defendant claimant in a declaration that the claimant stroke defendants to counterclaim continued occupation of the official accommodation is unlawful and unjustifiable. The claimant is an expatriate and he refused to give up possession because the defendant failed to pay his monthly and his salary in July 2015 due to him. The first wrong was by the defendant's counterclaimant, who breached the contract of employment by failing to pay the claimant's incremental salary of 500 US as stipulated in the contract. The claimant was a licensee in the official accommodation. I don't know whether counsel can hear me.
No, we are hearing you.
The claimant was a licensee in
No, we are struggling to hear.
You are struggling to hear.
Yeah.
But you can hear me.
Yes, yes, madam.
Okay. The claimant was a licensee in the official accommodation given to him and ought to have vacated the premises upon his resignation. However, this is no license. See the cases of Mwana versus FCDA and others. Also see Dr. Benchuku versus SPDC. However, this is no license for the defendant counterclaimant to resort to self-help and forcefully evict the claimant as admitted by DW in cross-examination. The defendant is not entitled to take possession of the premises by strong hand tactics. The defendant's counterclaimant ought to know that it should have applied to the court for possession and act on the authority of the court. There is no room for the use of self-help by force, and no one is entitled to take the law into his hands. The essence of the rule of law is that it should never operate under the rule of force or fear. The Supreme Court, in the case of military governor of Lagos State and others, versus Chief Emeka Ojukwu and another, Per Esho JS, stated the position succinctly, and I quote, "To use force to effect an act, and while under the marshal of that force, seek the court's equity, is an attempt to infuse timidity into courts and operate a sabotage of the cherished rule of law. It must never be." End of quote. There is no doubt in my mind that the declaratory order and damages sought by the defendant's counterclaimant in the counterclaim is an attempt by the defendant to infuse timidity into the court and operate a sabotage of the cherished rule of law. And this court will not allow this to happen. The defendant has not come to equity with clean hands, but in sabotage of the rule of law. The declaration and damages sought by the defendant's counterclaimant must fail. They are hereby refused. The claim for the sum of 1,039,090 naira as excess payments made to the claimant has not been proved. It is refused, and so is the claim for costs. On the whole, the counterclaim I find to be frivolous and lacking in merit. It is dismissed in its entirety. Cost of 250,000 naira awarded the claimant on the counterclaim. I hereby order the defendant to pay the following sums to the claimant for the avoidance of doubt. 1, the sum of 2,339,034 naira 19 kobo being unpaid salaries and allowances. 2, the sum of 6,000 United States dollars being the equivalent of 1 month's salary as general damages in the naira equivalent using the official rate ruling on the date of payment. 3, the sum of 500,000 naira as total costs awarded in favor of the claimant. All sums are to be paid within 14 days thereafter. 10% interest per annum compounded every month will be paid on the sums for any part outstanding until final liquidation. Judgment is entered accordingly.
As the court pleases. My Lord, we are indeed very grateful for your Lordship's brilliant analysis. And we must say that your Lordship has displayed industry in the delivery of this judgment. My Lord, we are very grateful.
Well, we are grateful for the judgment.
The judgment, physical copies of the judgment, physical copies of the judgments will be sent to the registrar in Lagos, and the soft copy will also be sent to the registrar. You will get the soft copy of the judgment first. So the registrar of the court will send counsel the soft copy of the judgment pending when the physical or the hard copy is forwarded to the Lagos division.
As a court, please.
As a court, we are grateful, sir.
The court will rise.
Right.
Yeah, thank you very much, sir. Thank you very much.
Is that right? Congratulations.
Mr. Amrari is okay.
Yeah, I am coming back very soon. Yes, thank you very much.
Is that right? You are crying. You have money now. You are crying.
No, my dear, how much I suffered, only God knows. Only God knows.
Anyway, I wish you were congratulations, sir.
All right, thank you very much.
Thank you very much. Okay, bye.
Wow. It's a national industrial country. He gave judgment against us, not in our.
Do you want to appeal?
What do you think will happen? Huh? What do you think? What do you think will happen? We're going to appeal. There's no fear about it.